In this podcast, we talk about the forbearance to sue. Now, the reality of litigation is that cases rarely go to trial, and reasons are that it is very expensive and it takes a long time, and even if you win at trial, you've lost a great deal of money getting there. So there are a lot of settlements, and that settlement is one of the ways a plaintiff can forbear from suing. There are a lot of advantages to forbearance. For the plaintiff, there's the certainty of something, which is the settlement, against the possibility of nothing, as in if the court doesn't rule in his or her favor. The defendant, the advantages are the certainty of a small cost against the possibility of a larger cost if the court rules against him or her. There's also a public policy in favor of forbearance. It is in the public interest when there is forbearance from suing, provided the settlement is genuine and freely entered into. And as you can imagine, the reasons are that the judicial burden is lightened and parties are able to financially plan. So financial planning is facilitated when there is forbearance, it cannot be if a case is in trial for years. Forbearance to sue can take two forms. Now, first of all, forbearance and consideration. A promise can be made by a prospective defendant to persuade someone, by the prospective plaintiff, not to bring legal proceedings. And in that way, the prospective plaintiff is thereby forbearing from suing. Now, one of the ways that forbearance happens is that the prospective litigant can refrain from taking an action in return for the promise of the intended defendant. The second one is once you have an action commenced, that can be settled by such an agreement. So forbearance can happen before an action is ever commenced, or once an action has commenced, then it brings an action to an end. And the rule is that forbearance to sue is good consideration. It means that the resulting agreement between the parties will be valid and enforceable. And whether the proceedings to enforce the disputed claim have or have not been instituted is irrelevant. Why is forbearance to sue good consideration? What is each party either giving up or conferring on the other party? Well, if the plaintiff would have succeeded at trial by forbearing, the plaintiff suffers a detriment of forbearing on the full value of a valid claim, and the defendant suffers a detriment of paying the settlement to the plaintiff. What if the plaintiff would have succeeded at trial by forbearing? Where's the consideration there? Well, it's obvious that the defendant suffers the detriment of providing a benefit to the plaintiff. But does the plaintiff suffer a detriment? Well, not really, because the plaintiff would have won. But the thing is, the plaintiff doesn't know that at the time he forbears from suing, which leads us to one of the requirements that must be present for forbearance to sue to constitute good consideration. Requirements for forbearance to sue constituting good consideration is that it will only be good consideration as long as the party threatening the lawsuit is acting in good faith. Means that as long as there is a serious intent to pursue a claim, the party forbearing will be acting in good faith. Even where the claim is clearly invalid, but the party forbearing is acting in good faith, i.e., she doesn't know that the claim is invalid, she has full intention to pursue the claim, that is the party acting in good faith. That is the party having a bona fide belief that she has a fair chance of success and a reasonable ground for suing. But if the settlement is not entered into in good faith, then the promise to forbear is not good consideration. In BDC and Arkin, the plaintiff's son was caught shoplifting by Zeller's undercover security agent. Subsequently, Zeller's legal counsel wrote a letter to the plaintiff stating that it wouldn't pursue legal action if the plaintiff paid $225. The plaintiff paid it, the $225, but then decided to bring legal action. A bit of background here as to this program that Zeller's had. Zellers had instituted what it called a loss recovery program in its store. And under this program, Zellers threatened civil lawsuits against shoppers who were caught shoplifting in Zellers. And under this program, Zellers would have these items that were lifted restored to Zellers. But then after that, Zellers was entitled to recover a contribution from each shoplifter toward the incremental cost of shoplifting for Zellers, which was basically the cost included in paying security guards to monitor the store. So what Zellers said was, if the total costs of the expenditures are calculated and then divided by the estimated total of shopping incidents, then the incremental cost per incident was calculated. Now, after that calculation, Zellers would claim, quote, a civil restitution claim, a claim against the shoplifter for a smaller amount than the incremental cost it had arrived at. And this it called the settlement fee. If the shoplifter refused to pay the settlement fee, Zellers threatened to proceed with a claim against the shoplifter for restitution. Restitution being the amount that Zellers was spending to hire security personnel. Now, if you're thinking that this sounds very dubious, it is. The merits of this were quite dubious. But what made it even more problematic was that Zellers would claim against parents and bring similar threats against them if their children were caught shoplifting. So here, can forbearance of a claim that has no prospect of success amount to sufficient consideration? And the court said, forbearance to sue is good consideration. Monies paid in exchange for a promise not to sue is a valid and enforceable legal contract. But there are qualifications. The promise to pay money is not binding if the sole consideration for it is a forbearance from pursuing a claim which is invalid and which is either known by the party forbearing to be invalid or not believing by that party to be valid. Or if the claim is doubtful, forbearance to enforce it is good consideration. So here, Zellers' claim was invalid. The entire program was very dubious, but it is clear that a claim asserted against parents for what their children did is clearly invalid. You cannot sue a parent for the tort of a child. Parents are not liable for the torts of their children simply by virtue of their status of being parents. They can be liable if the parents themselves are negligent or the parents engaged in tortious conduct in relation to the activities of their children, but not simply by their status of being a parent. And here, the plaintiff was not negligent, so she was not, in fact, liable for the tort of her child. Here, the Zellers' counsel would have known this, would have known that Zellers was not going to be pursuing this claim. Nonetheless, counsel was sending out letters to parents of these children and threatening to pursue these claims unless parents paid their settlement fee. Now, if you're thinking that this brings in some ethical issues, it certainly does. Lawyers uphold the rule of law. We do not use our legal skills and our authority to get money or benefits for our clients that our clients are not legally entitled to have. Basically, the lawyer here is helping Zellers extort people. So there are a lot of problems in this case, but fundamentally what you take is that any forbearance to sue must be undertaken with good faith. There has to be a bona fide belief that this is a valid claim. Otherwise, the settlement is not going to be upheld as a valid legal claim.